Generative models and autonomous agents are arriving in courtrooms. To manage this influx, the judicial system needs a practical standard. Blanket bans on technology ignore its utility, while universal disclosure rules would bury courts in administrative filings for routine tasks. To solve this efficiency problem, Judge Martin B. McGee authored a working draft for a model administrative AI order. The order does not rewrite the federal rules of civil procedure. It does not dictate whether specific evidence is admissible. Instead, it functions as a triage framework to help courts manage technical disputes before a trial begins. The framework splits AI applications into two distinct categories: advocacy or evidence. Using an LLM to draft a summary judgment motion falls under advocacy, requiring no disclosure. Conversely, generating a factual chronology as an exhibit crosses into evidence, requiring strict disclosure. By dividing the workflow, the court prevents administrative bloat. Attorneys can freely use software to prepare their arguments, while fact-finders are protected from untested synthetic data entering the record. Regulating AI in litigation is an exercise in preserving the adversarial process. The system ensures opposing counsel retains their right to cross-examine and test the reliability of proof. The advocacy branch covers tasks strictly internal to the legal team. This includes routine legal research, drafting pleadings, and executing privilege review. Tools like technology-assisted review, or TAR, and predictive coding also fall into this category, provided they are used solely to filter and search documents for production. This branch requires zero AI disclosure, because existing ethical obligations already govern the output. Federal Rule of Civil Procedure 11 and the duty of candor hold the filing attorney fully accountable for every document they submit. Opposing counsel can easily cite-check a brief to test its validity. They do not need a technical disclosure form to determine if an LLM hallucinated a case citation. The legal error will be obvious on its face. These tools are subject to a strict human-in-the-loop requirement. A qualified human must independently verify all AI-generated output before filing, guarding against known cognitive traps: automation bias, confirmation bias, and anchoring bias. Attorneys cannot outsource their Rule 11 accountability to black box systems. The human signature on the filing remains the ultimate, non-negotiable guarantee of legal accuracy. The rules change entirely under the evidence branch. This category is triggered the moment AI is used to create or materially alter proof that will be offered to the fact finder. Examples requiring strict disclosure include synthetic media and deepfakes, AI-altered photographs, and software-generated or translated transcripts. The dividing line is materiality. The court doesn't require disclosure for basic formatting, but mandates it for alterations affecting the substance of evidence. The core materiality test asks, would a fact finder consider the AI's role relevant to assessing the evidence's authenticity? To answer this, courts distinguish between analytic AI, which merely sorts existing data, and generative or agentic AI, which actively produces new content and synthesizes conclusions. Standard technology-assisted review workflows cross the line into evidence the moment the tool begins generating factual summaries that will be offered as proof.
When software stops organizing existing facts and starts synthesizing new ones for the jury, strict pre-trial disclosure becomes mandatory. The adoption of AI in litigation also introduces severe operational risks, specifically at the intersection of data security and discovery. The model order distinguishes between consumer-facing public AI tools and enterprise or protected AI tools. Public AI poses a severe risk to litigation. Information inputted into these tools may be ingested to train the provider's future models, permanently exposing sensitive case files. Submitting privileged information to public models waives attorney-client privilege. Instead, litigators must utilize enterprise or locally hosted AI tools. These secured systems provide technical safeguards, like data segregation and strict no-training commitments. The supervising attorney bears the responsibility to audit these systems and verify that third-party vendor safeguards actually function as advertised. Technological competence now requires litigators to understand exactly where and how third-party vendors store their prompt inputs. When a party identifies material AI evidence or suspects the opposing side is introducing a deepfake, specific procedural timelines apply. The order sets a strict deadline. Disclosure must occur no later than 90 days before trial.
If AI evidence is discovered within that window, immediate disclosure is required. Following disclosure, parties must immediately execute a meet and confer to discuss authentication protocols and expert witnesses. If a party seeks technical discovery regarding opposing counsel's AI systems, those requests are constrained by the proportionality limits of Federal Rule of Civil Procedure 26b1. To minimize the burden of production, courts favor vendor-provided validation studies and summary documentation over highly invasive source code discovery. These procedural mechanics are designed to force technical disputes out of dramatic mid-trial surprises, resolving them instead through structured, predictable pre-trial case management. The practical culmination of Judge McGee's framework is Exhibit A, the AI disclosure form. Completing this standardized form satisfies the complex technical disclosure obligations, clearly identifying exactly how AI interacted with the evidence in question. Recognizing the novelty of these tools, Section 8 of the order includes a safe harbor provision to mitigate attorney anxiety regarding sanctions. The court's primary goal is education and early identification of AI use, rather than punitive sanctions for inadvertent errors. Attorneys earn safe harbor protection by meeting 3 conditions: making timely good faith disclosures, taking reasonable verification steps, and cooperating in testing protocols. Maintaining this protection also requires fulfilling a self-correction duty. If an attorney discovers their AI hallucinated a fact after a document has been filed, they must immediately notify the court and opposing counsel. Existing procedural rules already provide the necessary mechanisms to test evidence, regardless of the technology used to generate it. The human-in-the-loop requirement establishes a clear line of accountability, making the signing attorney personally responsible for the validity of the work product. Success in this environment depends on a litigator's ability to apply established procedural safeguards to these novel systems, keeping human accountability central to the adversarial process.